The Repealing and Amending Act 2025 had just been passed, and it's a game changer for families dealing with wills. This new law removes a big hurdle many of us face when a loved one passes away. I have put a lot of efforts in this video. A single like, subscribe, or share would mean a lot. Please consider subscribing. Thank you.
Previously, families had to go to court to get a probate or letters of administration before they could act on a will. But now, with the removal of Section 213 from the Indian Succession Act of 1925, that requirement is gone. This change aims to make the inheritance process smoother and fairer for everyone, especially for Hindus, Buddhists, Sikhs, and Jains.
Alright, folks. Today we are diving deep into some legal waters. We will tackle big questions like what exactly is probate, what was Section 213 of Indian Succession Act all about, and what major changes it has brought, and why was it labelled as discriminatory. But hang on and stick around. This isn't a quick 30-second reel. Law isn't just a snack, it's a full course meal. So if you are ready to explore the juicy details and uncover the story behind the rule, let's get started. Trust me, it will be more fun than a courtroom drama.
The deletion of this section 213 has removed the compulsory requirement of obtaining a probate or letters of administration for wills from the concerned courts.
Now this was what Repealing and Amending Act of 2025 has done to Section 213 of Indian Succession Act. It has deleted Section 213 of Indian Succession Act, as we heard. But the main question now which arises is, what exactly is probate? So probate is a court order that confirms a will. After the person who made the will dies, a court case is needed to distribute their assets according to will. Now the court has two main tasks. Check that this is the final will. People can make several wills in their lifetime, so the court must be sure that this is the last one and no newer will exists. Second, see if any family member or legal has raised any objections to the will. If the court decides this is the final will and no one objects, then the probate is granted. Then the executor, that is a person named in the will as an executor, can carry out the wishes in the will. That is, in short, the court confirms the will, the genuineness of the will is confirmed, make sure there are no objections to the will, and once probate is granted, the executor distributes the assets as stated in the will. I know this might be a bouncer, not for legal students or not for persons relating to law field, but for common man, this all might be feel a bit heavy. So let us understand this all with a simple example. Now I will use the word testator. Who is a testator? A person making will when he dies is called as a testator. Meet Akhanda Singh, the testator. He makes a will naming the people who should get his assets after he dies. His wife Priya, his son Arman, and his daughter Meera. After Akhand dies, Priya, Arman and Meera go to court to start probate. The court looks at two questions. Is this Akhand's final will? Akhand has made a prior will years ago. So the court checks that this is the most recent and valid version and that no later will exists. Second, do any family members or any person interested related to will have any objections to this will? Priya, Arman or Meera or any other legal heirs can raise objections if they think the will isn't valid or not fair. If the court says yes, this is Akhand's final will and there are no valid objections, probate is granted. Once probate is granted, the executor. Now, who is executor? The person named in the will for handling the estate, for distributing the assets as per mentioned in the will. Now let's say Arman is named as the executor. Now the executor can distribute Akhand's assets exactly as written in the will. Priya gets certain assets, Meera gets a portion, and so on. So this is what all about probate. Once the probate is granted from the court, The executor named in the will to distribute the assets should distribute the asset according to the will.
What are the key takeaways we can say from this? Number 1, probate is the court's confirmation of the will and the process to distribute assets. Number 2, the court first verifies that this is the final will, that is, no newer will after it. Number 3, the court also considers any objections from heirs. Number 4, with probate granted, the executor carries out the will's instructions to distribute the assets.
Now, repealing of section 213, that is the requirement of probate, is no longer mandatory. So now you understand what section 213 has done. It has made the process of will easier. Means if there is a ready will, if there is an executor named in the will, then the executor, without any requirement of probate, without any requirement of court's order, can distribute the assets as per the will, and that will is equally legally binding without the probate. Have you ever wondered what happens if there's no executor named in a will? I was again and again saying if there is an executor named in the will, after probate he will distribute the assets according to the will. Executor named in the will then execute the will. But what if there is no executor in the will, and then what about probate? So that's a new video, that's a new explanation, that's a whole new concept. But for now, just keep in mind, if there is an executor named in the will, then there is no requirement of probate for the will, and the will is equally valid even without the probate. Now see this requirement of mandatory probate for certain categories of will. This is a requirement triggered not by complexity of estate or the existence of dispute, but by geography and religious affiliation. So this is the requirement not because of estate, not because of existence of any dispute. From where this requirement has been triggered? It has been triggered by geography and by religious affiliation. Now what I mean by geography and religious affiliation, that you will get to know after reading the repealed section 213 of Indian Succession Act. Now this requirement of mandatory probate, was it mandatory for all? And has it given a great relief? Then the answer is no. It was not mandatory for all. This provision was mandatory only under specific conditions, only to specific category of people and to specific category of property. That's what I said, religious and geographical affiliations. See, this was mandatory. Probate was compulsory for wills of Hindus, Jains, Sikhs, Buddhists. If the will was executed within the original civil jurisdiction of the High Courts of Mumbai, Madras or Kolkata, or if the immovable property for which the will is made was situated in those cities. Means, if suppose A is a person who is Hindu, who is residing in Mumbai, hence he has made will in Mumbai for a property which is situated in suppose Kerala. But since the will is made within Mumbai, probate was mandatory because it is executed within the original civil jurisdiction of High Court of Mumbai. Take a second scenario. If I am an Christian, Indian Christian, and I have made a will in Mumbai related to property in Kerala, then the probate was not mandatory, because even if it is executed in the original civil jurisdiction of Mumbai, the person making it is an Indian Christian, and for them this section 213 mandatory probate was not applicable. Similarly, if I am a person of Hindu or suppose Jain, and I have executed a will in Kerala for a property related to Kerala or Punjab, then the probate was not mandatory because it is neither executed in original civil jurisdictions of Mumbai, Madras or Kolkata, nor the property is situated in those cities. You can see on screen section 213. Right as executor or legatee when established. This section is now no longer valid. This has been repealed. First, no right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of the will under which the right is claimed, or has granted letters of administration with the will or with a copy of an authenticated copy of the will annexed. Now, this section shall not apply in case of wills made by Muhammadans or Indian Christians, and shall only apply on in the case of wills made by any Hindu, Buddhist, Sikhs or Jains, where such wills are of classes specified in clause A and B of section 57, and in the case of wills made by any Parsi dying after commencement of Indian Succession Act 1962, where such wills are made within the local limits of original ordinary civil jurisdiction of the High Courts at Calcutta, Madras and Bombay, and where such wills are made outside those limits insofar as they relate to immovable property situated within those limits. So, in practice, mandatory probates entrenched litigation as a default process. Even uncontested estates were compelled into court proceedings, immobilizing assets and converting succession into prolonged procedural exercise rather than a matter of orderly administration. Instead of preventing disputes, probate frequently became a forum for delay tactics and leverage by disgruntled heirs. See, now because it substituted geography for logic, attaching procedural consequences to the place of execution rather than to substantive risk. It produced formal inequality, subjecting similarly placed heirs to different legal burdens without justification. Because the position of all the legal heirs is almost same. But then why only to certain categories of people residing in certain local limits and having certain religion only subjected to compulsory probate requirement and others were not subjected? So this was very illogical thing which was not based on logic but was based on geography and religion. This is the repeal of mandatory probate provision. So that doesn't mean that you cannot go for a probate. If there are disputes and if there are complexities in your will, then still probate is valid. You can apply to court for probate. So for many estates, especially those involving complexity or potential conflict, voluntary probate will continue to be a smart and protective move. Probate has not disappeared from legal landscape. It has merely changed its character from an imposed hurdle to an informed strategic choice. So now succession law offers greater flexibility. With that flexibility comes responsibility for careful drafting, thoughtful planning, and informed responsibility for decision making.